that we would like to have to mail this recording to anybody, at least you can request it. So our format for today is just getting straight to the point here, is we are muting everybody's microphone. If you want to ask something, you can always type in the chat box. And when there's an opportune time, I'll read out your question. But when we come to the end of our presentation, after about 30 odd minutes, we're going to open the floor for people who can raise their hand, and then we'll put a question to our attorneys or to Donita that is participating this morning. So we're planning to have a maximum of 45 minutes. We're going to stick to the point. And as I said, I trust you're going to find some value in this morning. So I just want to welcome you all, and I also want to welcome Donita Leroux, Harcourt's Platinum's rental manager. Here from Smith to Barta Buchanan Boys, we've got David Thompson and Wesley Graham on board this morning, who are going to be talking on the state of disasters impact on lease agreements. We have some time for Q&A. And the very last little slide, I'll have contact details for Harcourt's Platinum. If you don't have it yet, that you're welcome to obviously mail us, call us, specific to Donita, and who can maybe forward the link of this recording to you or give you any kind of other advice that you'd like to do. So Harcourt's Platinum has a book of roughly about 480 rental units. We've seen from a national manifestation level that quite a number of tenants are getting in trouble with paying their full rental, only paying partly. As a matter of fact, TPN has announced a figure of up to 30% of rentals in the month of April that has gone either partly paid or unpaid. And the reason for today's session is really to get all the current information to let people know what am I entitled to do, what is still against the law to do, and I'm sure that our very competent attorneys is going to delve into that. So just very quickly, for about 3 minutes, I want to hand over to Donita Leroux, the rental manager for Harcourt's Platinum, to just quickly chat about what can you expect your rental agent to actually do on your behalf. And if you are contemplating on maybe doing a rental yourself, or you are currently doing a rental yourself and you are a landlord that is logged into today's webinar, what is expected of you to do with your tenants, and what does the Rental Housing Act actually demand? So Donita, if you're ready to rock and roll, the floor is yours. Switch that video on and let's hear from you.
Hi, morning. Can you all hear me?
We can. Hundreds.
Okay. All right. I was asked to point out 5 obligations that a rental manager has to fulfill on behalf of the landlord. And I took the 5 most important, starting with the marketing. So the marketing is vital. We do comprehensive marketing, which gives the landlord the exposure, which results in more quality applicants to choose from. The second most important is the screening of tenants. It is almost impossible to find that perfect tenant, but there are many steps that we follow to ensure that we find the best tenant. We make use of TPN to perform credit and reference checks. The TPN report offers a complete background check on each and every tenant, which will then include the tenant's previous history of rental payments with other agencies. The third point is vital, which is your property inspections. We do an ingoing, midterm, exit inspection when a tenant moves out. All inspections are performed with the tenant. We make use of red rabbits to record and photograph all default snags during each and every inspection. Once concluded, the report is signed by the tenant and the agent on behalf of the landlord. The copy of this report is then sent to both parties, and then we file it. The fourth point, I would say, is the collection of rental. We make use of PayProp to invoice tenants for their rental and utilities. We also make use of TPN to issue letter of demand or letters of cancellation due to no payment or late payment of rental. The fifth point, I would say, is maintenance. Over the years, we have selected quality contractors that we use to help with any damages or repairs to properties. We never authorize any repairs without a landlord's approval. Repairs are paid from rental that we receive at month end. From time to time, we do arrange for payment plan with the contractor should a repair exceed the monthly rental income. So yeah, that's my 5 points on my side.
Appreciate that, Donita. I think that as you are in the hot chair that Donita is, you'll find that you hardly ever have both parties happy in a rental agreement. It's either the landlord that feels that they've been done in one or other way, or it's the tenant that maybe feels that way. So I think Donita's always been doing an awesome job, always just owning up for any of the questions and the demands that many times come from that. So, and I mean, in a time like this, it's even harder. There's one department that's certainly been working full steam or even more than ever before during the lockdown, and that's definitely the rental department due to this very peculiar circumstances. Without any further ado, I would like to introduce to you David Thompson and Wesley Graham from Smith DeBarter Buchanan Boys, who's going to be doing our little presentation this morning. So gentlemen, we really want to thank you for your time and your input. You've been doing this now for a while. We believe that you are the most up-to-date people from what's happening within the whole rental sphere. So the microphone is yours. Entertain us. Thank you.
Yeah, Jan, thank you very much. Thank you to Harcourts for the opportunity to present to you guys and to your clients alike. We really, really appreciate it. And I think it's great that, that we get this platform to be able to speak to people. The more people that know their rights and the more people that know what's going on, the better. It's better for the industry as well. So once again, thank you very much and a very warm welcome to all of our listeners and attendees this morning. As Jan said, my name is David Thompson. I am a director at the litigation department at our Cape Town branch. I am joined by my colleague Wesley Graham, who is an associate also in the litigation department here in Cape Town with me. In fact, Wesley is about 10 meters away from me in the other office, but because of social distancing, we are adhering to that. So guys, this morning, what myself and Wesley are going to be chatting to you guys about is just, it's just a brief presentation really on rights and obligations of tenants and landlords during the lockdown period. This is a presentation that we've been doing throughout the lockdown. And predominantly the reason why we've got this presentation and why we have been doing the presentation is really because a lot of uncertainty, has come up regarding payment of rental during this time. Am I supposed to pay rental? Can I have a payment holiday? Am I obliged to give you a payment holiday? All these kinds of things. So we'll be touching on these aspects, both from a commercial and from a residential aspect. And to get us started, I'm going to let my colleague Wesley Graham kick us off to talk us through the first steps. Wes?
Thanks, Dave. Can everybody hear me okay?
100%. Do we get you?
All right,
Thank
great.
you.
Hundreds. As David said, my name is Wesley Graham, and I'm an associate in STBB's litigation department in Cape Town. I specialize in sectional title dispute resolution, as well as sale and leasing dispute resolution. And obviously today we're going to be talking about the leasing side of things. So first and foremost, I don't need to, speak about COVID-19 and, what it's done to our leasing industry. I think we're all aware of the impact that it's had on rentals as a whole. And, I think the most pertinent question one, needs to answer at this point in time is, the tenant allowed to withhold the rental as a result of COVID-19? That's, the main question that I'm receiving as an attorney. And look, guys, there is no easy answer to that question. However, we do have a few, points that we'd like to discuss with you as managing agents and landlords, and perhaps maybe even tenants alike. So, if a tenant approaches you and as the agent or as the landlord and says to you, look, I can't make payment of the monthly rental, I've fallen on hard times, what do you do? So the first thing one needs to do is look at the agreement, look at the lease agreement. We know that a lease agreement contains all the rights and obligations of both parties. We know that the landlord is obliged to give the tenant occupation, and in turn, the tenant is obliged to make payment of the monthly rental. So those are the rights and obligations, or the essential rights and obligations of the lease agreement. Now, if the agreement includes a force majeure clause, which is a clause that deals with non-performance of obligations as a result of a force majeure, then obviously the parties are bound by the agreement and that specific clause. They must deal with the particular non-performance as per the agreement. Now, in the likely event that the agreement is silent on force majeure and doesn't include a force majeure clause, the parties are then required to rely on the common law, which is the common law principle of a supervening impossibility of performance. Now, what this common law principle tells us is that it must be objectively impossible for a tenant or a landlord to rely on a particular clause in order to avoid performing his or her obligations in terms of the agreement. And it's very important to remember that the principle of supervening impossibility of performance is actually a defense that must be raised. So I say that because, obviously if your tenant doesn't pay, your landlord's entitled to place the tenant in breach of the agreement. And he may very well do that, and at which point the tenant will raise supervening impossibility of performance as a defense as to why he can't pay the monthly rental. And then obviously, the tenant has the obligation to prove that he actually can't make payment of the monthly rental. The landlord then decides to accept that he can't make payment as a result of, or it's impossible for him to perform. We must remember that the agreement then terminates, and the tenant must then vacate the property. Obviously, that is now allowed, but I'll leave that. David and I will touch on the new regulations a little bit later. But in a nutshell, to summarize what I've just...
Sorry to interrupt, Wes. We just got a comment there. Your audio is coming in and out, so maybe just try and stay still.
I'm going to bring my laptop closer. Is that a bit better?
Yeah.
Okay, great. All right. So in a nutshell, if you as a landlord have a situation whereby your tenant says to you can't pay, first port of call, look at your agreement. What does your agreement say about non-performance of obligations as a result of a force majeure? If your agreement is silent and it doesn't include a force majeure clause, then you must look at the common law. And what does the common law say? Dave, I think I will hand over to you.
Thanks, Wes. Yeah, guys, just to recap what Wes said there, the starting point, whenever there's a situation regarding non-payment of rental, the starting point is always the lease agreement, guys. You first look to the lease agreement to see what the rights and obligations are of the parties. If the lease agreement does not give you the answer that you're looking for, you go to the common law, which is what Wes was talking about now. And in our common law, we have these fancy Latin phrases, which are vis maior and force majeure, and these kinds of things. And what does this actually mean? Okay. Well, I think it's safe to say at this advanced stage of our lockdown that the lockdown itself is what is being referred to as a vis maior. Okay. A lot of people are saying it's the COVID-19 virus. But if you look at the COVID-19 virus in isolation without the lockdown regulations, that wouldn't necessarily be a force majeure or a vis maior, okay? What is causing the distress to people out there and the distress to our economy is actually the regulations that have been implemented and which have resulted in the lockdown. So it's the lockdown, guys, that is causing the difficulty, right? And what the common law says about these fancy phrases is that if it is impossible for someone to do something, then in theory, what should happen is that contract should terminate, okay? If it's impossible for someone to do something. And when we talk about an impossibility of performance, guys, it is an absolute impossibility. And it must be judged on objective criteria, okay? So examples of things that might become objectively impossible are, for example, situations where there's a lightning strike or lightning strikes your house, which causes the house to burn down. There's a civil war and the house is bombed and the house is destroyed. There is an earthquake, and as a result of the earthquake, the house falls into a crevice in the ground and the house is destroyed. These are all examples of absolute impossibilities. And why do I say that? Is because in all of the examples that I've just given you, the property would be destroyed, and it would be impossible, objectively impossible, for the landlord to give you the house or the premises to occupy, and it would be objectively impossible for the tenant to take occupation of that premises because there is no premises. So that's where your thinking must be at, guys, when it comes to objective impossibility, and when it comes to people saying things like supervening impossibility, or if it is impossible for me to do something. That is why, under the present sort of climate, you know, in the lockdown situation that we find ourselves in, we at STBB have taken the stance that difficulty to pay or inability to pay as a result of a pay cut or as a result of someone losing their job, unfortunately, guys, is not going to be seen as an objective impossibility. That is our view at this stage. And please, guys, remember, these are very unprecedented times. South Africa has never faced a situation like this before. So how the courts are actually going to deal with these kinds of situations moving forward is not yet known. We can only advise on the law as we interpret it at the moment. The courts may very well develop the law in due course. So the advice that we are giving you now is based on the law as we see it at the moment. It could very well change in the future. The courts might interpret or apply the law differently in the future. So please, as a disclaimer, just keep that in the back of your minds. But at the moment, the position we're taking is that a difficulty to pay is not an impossibility to pay, okay? And I really want to stress that point, and I want everyone to be very clear on that point. And that is something that I need everyone to understand very carefully. I'm seeing here, just before I hand back to Wesley, a couple of questions that have come through already. The first one was from Roy. Can a tenant use COVID-19 as an excuse to withhold rental payments? And the second question came from Merv. A tenant can thus not withhold rent without any proof that they are unable to meet the criteria. So quickly, guys, just to answer those two questions in brief, the tenant cannot use in a residential sense. It might be a little bit different in a commercial sense, which I'll get to in due course. But in the residential sense, generally speaking, no, they cannot use COVID-19 as an excuse to withhold payment. There's no such thing as a payment holiday in the residential rental space. And a tenant can thus not withhold rent without any proof that they are unable to meet the criteria or the rental obligations. Also no, because it's not a question, guys, of not being able to pay or it being difficult to pay. That is not an impossibility. That would not excuse someone from paying. So that wouldn't release someone from the obligation of paying. What that might trigger is a situation where you can negotiate terms, but Wesley will also deal with that in due course. So just on those 2 points, I hope I've answered the question. Roy, certainly not. They can't use it, generally speaking, in a residential sense. They can't use it as an excuse. And Merv, Wesley is going to touch on alternative dispute resolutions next. So Wes, I'll hand straight back to you.
All right, thank you. Okay, guys, so let's run a practical scenario. Tenant messages the landlord or the managing agent and says, listen, I can't pay. I can't pay the rental for May. Sorry. What do we do? So my advice to landlord and managing agent clients alike is to put the tenant in breach of his obligations arising from the agreement. Now, remember, we said earlier, if a tenant is in occupation of a residential property, there's no reason why he mustn't pay. He's enjoying the benefit of that occupation and the use and enjoyment of that property, and therefore he must pay for that use and enjoyment. So my advice to landlord clients and managing agents alike at this point in time is reserve the landlord's rights arising from the agreement. And what we're doing is we're sending out notices of breach, and we're calling upon the tenant to remedy his breach by making payment of May's rental within 20 business days if the Consumer Protection Act, more specifically Section 14 of the Act, is applicable. Or alternatively, and to the extent that the CPA is not applicable, the period of time as stipulated in the contract within which the tenant is required to remedy the breach. It's usually 7 days, but remember, look at your agreement, enforce your agreement. So we're sending out these notices, and you know, sometimes we receive responses from the tenants, and the tenants say, look, unfortunately, my financial circumstances, you know, or rather, I'm suffering financial prejudice, and I can't make payment of the monthly rental. Sometimes they don't respond, and the 20 business days or the 7 days expire, in which case, in both scenarios, shifts back to the landlord, and the landlord must then make a decision. And the decision is, well, either he elects to terminate the agreement, in which case we then send a notice of cancellation as a result of the tenant's failure to remedy his breach, in which case we call upon the tenant to vacate the lease premises. Now, prior to 7 May, we were saying the tenant needs to vacate the lease premises when the regulations permit movement. But earlier on today, I drafted a new notice of cancellation, and I've called upon the tenant to vacate the lease premises immediately, as the regulations now permit movement up until the 7th of June. So we can call upon people to vacate during this window period. Now let's talk about the instance where your landlord client says to you, hell man, I don't want to terminate this agreement. You know, I like this tenant, he's been with me for a long time. I feel really sorry for him. He's provided me with proof of his financial circumstances. I can see he's fallen on hard times. I feel terrible for this guy. Let's see if we can help him out. In which case your landlord client will tell you as the managing agent, please don't cancel the agreement. Rather negotiate with the tenant and see if we can come to some sort of compromise in the circumstances. And your landlord client is going to say to you as the managing agent, well, what do you suggest I do in these unprecedented times? And you as the managing agent are possibly going to say to your landlord client, well, look, first things first, let's see if we can negotiate a reduced rental for a stipulated period of time, perhaps maybe 3 months. And, you know, let's see if that will help our tenant. And in addition, let's maybe see if the tenant will give us permission to use a portion of his deposit to cover the reduced rental for that stipulated period of time. And maybe then we can also say to the tenant, well, look, you know, whatever we use from the deposit, you're going to have to top up after the 3-month period once, you know, the status quo has reverted and once your financial situation has improved. And at the same time, you know, and to the extent that your lease agreement that perhaps maybe only has 2 months left to run, your landlord client might say to you, you know, we don't want to place too much of a financial burden on the tenant. So let's offer the tenant a renewal for another year. And, you know, for that period of time, he can pay the monthly rental plus the top-up amount in order to reinstate his deposit so that I have my security. Now, guys, everything I'm discussing with you at this point in time is called alternative dispute resolution mechanisms. And I'm advising my landlord clients to make use of these alternative dispute resolution mechanisms at this point in time, given that you don't want to be evicting tenants right now. The court process is non-existent at this point in time. The regulations do say that you're allowed to bring an eviction application, but you can't execute on the eviction order until the last day of the level 4 lockdown. When is that going to happen? I mean, at this point in time, there's just too many unknowns. So I'm trying to steer my landlord clients away from the cancellation and eviction kind of route to a more more of a compromise, you know, situation in terms of which both parties can benefit. And And for the most part, thus far, we've concluded addendums along the lines of what I previously discussed. Parties have been open to negotiating reduced monthly rentals for a stipulated period of time, usually about 3 months, and using the tenant's deposit or a portion thereof to cover the reduced monthly rental for that stipulated period of time, and then looking at ways to reinstate that deposit after the period of time agreed upon by the parties. So we are concluding addendums to that effect. I've looked at it and I don't have a problem with it. And it seems to be working because, you know, at the end of the day, landlords and tenants are symbiotically linked. And we need to remember that. And when this thing does pass, and it will pass, you know, you want your tenants to remain in occupation. You want, as a landlord, you want to be receiving that passive income. You don't want to be fighting, you know, you don't want to have to evict the guy and go through that whole process, because I'm sure we all know that that process takes up to 18 months sometimes. And, you know, finances are tight at this point in time, and it's very expensive to evict somebody. You know, I don't need to tell you guys that. I'm sure you're all aware of the costs to throw somebody out of a premises. So I think the point that I'm trying to make is compromise, guys. Compromise. You know, we all need to do our bit in these unprecedented times, and I think making use of alternative dispute resolution mechanisms are the way forward right now, from a residential point of view. So I'm going to hand over to Dave, who will now take us through the commercial aspect pertaining to these agreements.
Thanks very much, Wes. So just to recap on what Wes was saying there, guys, basically what we need to do is we need to be mindful of the fact that there is a lease agreement in place, okay? And as we said when we started our chat this morning, the starting point is always the lease agreement. So if people are falling into arrears, if people are having issues with making payment or not making payment, follow the provisions of the lease agreement. Follow the breach provisions in the lease agreement. Send out your letters of demand. You know, put your defaulting tenants on notice, okay? And if the tenant has an issue about making payment, the tenant has the obligation to raise the issue. It's not for the landlord to engage with a tenant regarding whether they can or cannot pay. As far as the landlords are concerned, the obligation is there. The tenant must pay. And if the tenant can't pay, the tenant is the one who has the obligation either to raise the defense of a supervening impossibility, which, as we've said, is unlikely, or the tenant must attempt to use alternative dispute resolution mechanisms. They must approach the landlord or the managing agent. They must say, look, guys, you know, I am impacted by COVID-19. I am struggling to make ends meet. I've taken a pay cut. Can we renegotiate? And that's where we're calling upon landlords to be mindful of what's going on in the country and worldwide, and try and be reasonable. Try and accommodate people where you can. Legally, in terms of your contract, you can enforce the contract. So that's the legal position. But alternatively, you know, there are also ways that we can assist each other during this difficult time. And we would also encourage people to make use of the alternative dispute resolution mechanisms, especially if the tenants have been a good tenant, you know, if they've taken care of the premises, if they've traditionally paid on time, you know, these kinds of things. If there's still a long period left on the lease and they have been a good tenant, you want that kind of tenant to be in your premises in any event. So where possible, try and negotiate. You don't have to legally, but it is a suggestion. And as Wesley has correctly pointed out, evictions during this time are complicated. They're not straightforward. Not that if evictions in the normal course of business are straightforward, but even more so now during these lockdown periods. You are, in theory, allowed to go to court to get an eviction order, but even if you get an eviction order tomorrow, that eviction order is not going to be implemented until the end of level 4 at the very least. So alternative dispute resolutions is perhaps something to consider. Guys, up until now, Wesley has been chatting to you about the residential aspects. Jan?
Can you just quickly answer that little question of Roy Harrington there? If it eventually goes to court, who is responsible for cost, tenant or landlord, when the tenant breaches the contract? Then at least we're sort of done with this part of that conversation. Thanks, David.
Sure. Thanks for bringing that to my attention, Jan. Roy, if anyone, the general rule about litigation is that the successful party must be awarded their costs. So if the landlord has lawfully cancelled the agreement and has proceeded to court either to reclaim arrears or to get an eviction order, the court may order the tenant to pay the costs of that application. And please also be mindful, Roy, it's 99% of the time, it's not a 100% recovery on costs. Normally you're looking anywhere between 50, generously 70% recovery on costs. But it's highly unlikely that you'll ever be completely indemnified from costs. So generally speaking, the tenant would have to bear those costs if he's breached the agreement. I hope that answers your question, Roy. Fixed up. Thanks, Jan. Guys, moving on to, sorry, before we close this chapter, Merv also has a question there. Will the tenants still be expected to pay rentals after eviction procedures are started? Merv, yes, insofar as the tenant remains in occupation after the lease has been cancelled, the landlord will have a claim for what's called holding over damages, which the landlord will have to prove in due course. But the rule of thumb is, for so long as the tenant remains in occupation, they must pay the rental.
Dave, can I jump in here very quickly?
Yeah.
So, Merv and other managing agents, it's very, very important when you issue your invoices after cancellation, not to reflect rental. We don't want to be tacitly renewing any agreements that have been cancelled. So please, if the tenant remains in occupation after you've cancelled and once the eviction process has been initiated, please, please, please do not label your invoices with the word rental. You need to call it holding over damages.
Thanks, Riz. That's a very valid point.
And the reason for this is you do not want to reinstate the agreement, and you do not want to give the tenant a defense, which he can raise in court. So holding over damages for the period after cancellation going forward, until such time as he vacates.
Excellent. Thanks, Wes. Guys, moving swiftly along onto commercial agreements, for those of you who are involved in the commercial space of letting. As Wes has discussed the residential aspects, there's a slight difference when it comes to commercial leases. And the reason being, guys, during the lockdown period, the tenants should be confined to their home more so than ever, barring essential services people, barring people who are allowed to work. But on the whole, at the moment in the residential space, people are getting the maximum use and enjoyment. And we also refer to this as the beneficial occupation of the premises, because they are in the premises, they have to be in the premises, they're using the premises. When it comes to commercial leases, it's not so simple, because a lot of companies have been told that they are not allowed to operate. So what this means is that a lot of commercial tenants are not getting the full use and enjoyment of their property that they are leasing. And they are also not, then said otherwise, getting the full beneficial occupation of the commercial premises, okay? And what this means is that in certain instances, from a commercial space perspective, the tenants would be allowed to claim a remission on rental, which would have to be worked out almost on a pro rata basis, in a sense of what use they are getting from the property and what use they are not getting from the property. And I say this because if you take a large retailer, for example, let's use Edgar's, for example, the space that they rent, they are not getting the full beneficial or the full benefit of that space, but they are getting some benefit, because if they didn't have that space, they would have to go and get storage facilities somewhere to store all of the goods that are in that space. So there is a benefit to them. They are storing their goods in the property, albeit that they're not getting foot traffic, they're not getting customers coming in and out, there is still a benefit. So their claim would be for a remission or a reduction on rent for those months where they can't use the property for which it was intended. But guys, I say that with a huge disclaimer. our courts have recently held, and it's been held in the Supreme Court of Appeal, that depending on the wording of your lease agreement, some of those reciprocal obligations have been reversed, in a sense that it's not that the landlord must first provide you with occupation and then you must pay. Some lease agreements reverse that obligation. They say you must pay regardless of you getting occupation or not. So in the residential space and in the commercial space, the general rule of thumb, and I say general because it's very general, but the general rule of thumb is that you must pay now, under protest if needs be, and fight later. That is the general rule of thumb, but please guys, refer to your lease agreements, refer to the wording of your lease agreements. So that's the general rule of thumb. Wes, I just want to also just jump back one moment. I might have missed it, but insofar as alternative dispute resolutions are concerned, one of the questions that come up a lot is the use of the deposit. Did you touch on that?
Yes.
Okay, fantastic.
But I think maybe I should just elaborate very quickly. Look, guys, if you are going to use the tenant's deposit or a portion thereof to cover the rental or a reduced rental amount, it's very, very, very important for you to obtain the consent of the tenant prior to offsetting any amounts using the deposit. So please, please, please conclude addendums. Get both the landlord and the tenant to sign the addendum, and you as the managing agent sign it as well. And only thereafter can you utilize the deposit or a portion thereof to cover the rental or reduced portion thereof. It's very, very important. And then what I want you to do as managing agents as well is I want you to talk to your service provider who sends out the invoices. And I'd like you to please also reflect a debit and a credit. So debiting the deposit account, crediting the landlord's rental account, and sending that proof of the debit and the credit to the tenant. We have to do that in terms of the Rental Housing Act. It's a legislated obligation. So please, 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 if you are going to make use of that alternative dispute resolution mechanism, you need to make sure that you cover yourselves, and you need to do so as I've just discussed. But if you have any further questions, and if you want me to guide you on the process or help you draft addendums, my email address is on the bottom left-hand corner, and you're more than welcome to email me.
Fantastic, Wesley. Thank you for just clarifying that point. So Jan, yeah, that's our talk. We can move over to Q&A if you want.
I see. I see. Joe's asked a question.
There are two questions there, Joe's, and then I've also posted a question if you'd like to answer that. Thank you.
Sure. All right. So Joe says, I'm a private landlord and do not make use of a letting agent. So it's an unmanaged lease agreement. I do not send out invoices. Ooh. Okay. How do I deal with this, Joe? Please, you need to start sending out invoices. The Rental Housing Act says that you are obliged to do so. You don't want to, act in conflict to any legislation. So there's an obligation, a legislated obligation to send out invoices. So please do that. And as I previously said, if your tenant has given you permission to use a portion of his deposit to pay the monthly rental or the reduced rental, you need to reflect that on your invoices as well. So in essence, you're going to be sending out two invoices. One is going to be a statement pertaining to the deposit, which will show the deposit amount, and then any amounts moved out of that account. And then obviously the tenant's account, which reflects the rental. So please, 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 guys, you need to comply with your obligations in terms of the Rental Housing Act. Then Jan had a question. Does body corporates and HOAs have to play ball with the new permissions for tenants to move? Absolutely.
Wes, before you answer that question, there's just a follow-up question from Teresa. So I don't know if you want to just touch on both at the same time.
Sure. Are we able to touch on... Good morning, gents. Are we able to touch on the new direction issued last night regarding moving and exit and incoming inspections as required in terms of the Rental Housing Act? Well, so Dave and I had a lengthy discussion about ingoing and outgoing inspections, and you know, the effect on ingoing and outgoing inspections given the enactment of the latest regulations issued in terms of the Disaster Management Act. And look, there's no simple answer to this query, save to state that we are of the view that if a tenant is about to vacate the lease premises and the landlord and the managing agent aren't able to attend upon the premises to conduct the outgoing inspection, that the managing agent or the landlord must contact the tenant, and the outgoing inspection must be conducted using an online platform such as Zoom, Microsoft Teams, or even WhatsApp. What you will then do is you will take your ingoing inspection as the agent, and you will ask the tenant to walk around to the various points as plotted on your ingoing statement, inspection, and you will, to the best of your ability, try and assess any damage making use of the online platform. Unfortunately, that's the only thing we can do at this point in time. Regulations stipulate that managing agents are not allowed to operate during level 4, and landlords are not allowed to leave their houses for any other reason other than those reasons legislated in the previous regulations, which were enacted about a week ago at the start of the level 4. I think it's regulation 16. You can go and have a look at that in your own time, but it basically says that you can only leave your house if you're going to go buy food, or if you're going to work and you have a permit. Those are the only 2 times. Or I think there's four instances when you can leave, but for purposes of this discussion, those are the only times that you can leave. So you can't go and do an outgoing inspection. So we have to make use of technology in these unprecedented times, guys. And we, yeah, as I said, conduct the ingoing and outgoing inspections using the Zoom or an online platform. So Teresa, to summarize, you cannot do ingoing and outgoing inspections during the level lockdown. Physically, yes. Yeah. you cannot do physical inspections.
I'm sorry, before you move on there, where's Liesel? You can maybe just unmute your mic as well. Liesel Solomon is a senior associate in our conveyancing department. And STBB is going to be releasing a press statement regarding this topic shortly. And Liesel was involved with assisting drafting this document with one of our senior partners. So I'm just going to call on Liesel just to maybe touch on that in case Wesley's missed anything.
Okay. Morning, everyone. I'm just going to jump in briefly. So as you guys have, those who have read the regulations would see that they are quite vague in just setting out exactly what you can and can't do and who can be involved in this once-off movement from an old residence to a new residence. So first off, clearly you all do know that it is for leases that have been entered into before or during the lockdown period. It's very important that we know that the lockdown period is from the 27th of March to the 31st of April. That's what they mean, lockdown period. So any leases entered into before or during the 27th of March to the 31st of April, those are the leases they refer to. And then transfers, and this touches on Patricia's question that she's asked, transfers that have been registered before the lockdown period. Our last day for registration was the 26th of March. So if your transfer registered and you didn't have time to move into your property or move out of the property that you sold, that is what they are referring to when it comes to sales. So just so that we clear that off, it's a once-off movement that you are allowed to move from yesterday, the 7th of May, up until the 7th of June. The affidavit that you have to get from your police station would then state that you are allowed to move in terms of this lease. So you'll have your old, your new lease and your affidavit permitting you to move, or you'll have the proof that the property was registered. So obviously, if your property was registered on the 26th of March, you won't have your title deed, but then you can have a confirmation in writing from your conveyancer confirming the registration has taken place, or perhaps an offer to purchase. Whether they'll accept it, we don't know, but an offer to purchase that states the occupation date being that day. But I'm not sure, so you'll need some more proof to say that registration had actually taken place. The police station that you'll be attending, or you'll inform your clients they need to go to, is the station closest to your current residence. So if you are moving from Cape Town to Milnerton, you don't get an affidavit from Milnerton. You're going to be getting your affidavit from the nearest police station in Cape Town to allow you to move to Milnerton. And so those are the documentation that you'll need for moving. And like Wesley said, the particulars of your current lease agreements, you will, in order to conduct your inspections, you can do a virtual inspection. So this is if both parties agree to have a virtual inspection done, then you can do that. So your tenant can walk around and have a look at it, and your new tenant, if you have a second tenant moving in, can do the same. If parties don't agree to this, we've suggested, and this is what we are going to suggest to our clients, that us as your attorneys, we are operating under alert level 4, and the landlord and the tenant can furnish us with the power of attorney to conduct this on their behalf. So the exact wording of that, as well as the wording of the permits, which we'll be furnishing to you during the course of the day on our STBB, there'll be a link on our newsflash that will be going out. Will be there, but that is just an alternative solution if your clients are not happy with a virtual inspection. Other than that, Wesley, you can just discuss on the if clients refuse virtual or do not want to appoint an attorney to do this on their behalf, what their options are regarding maybe deposit and inspection. But that is something we'll look at. Again, very, very vague, guys. So we are trying to do the best to work out solutions that are both in terms of the regulations of level 4 and these new regulations. So I'm going to leave you guys with that.
Jan, I'm going to perhaps, we're getting a lot of questions in the chat section, and I'm just mindful of time as well.
Yes.
For everyone's commitments. You know, if necessary, I'm certainly, I mean, I can't speak for Wesley or Liesel, but I'm certainly happy to do a separate Q&A session, perhaps sometime next week. Yeah. If you want, just to get through everyone's questions. But I don't, just from a time perspective, I don't think we're going to get through everyone's questions now. But perhaps early next week, if everyone is willing, I'm certainly willing. We can do a special Q&A session for your listeners.
So what we can do is, Donita can collect maybe a number of questions, group them together so we make sure that we don't have an overlap of too many of them. Maybe we have got 6 or 7 main category of questions, like I see, like for instance, that a few here that already shows that. And then we can maybe just set up something new for a 30-minute kind of Q&A, and whoever would like to participate, even of today's participants, can just log into that new Zoom, and you will get the Zoom link either on our, from Donita, on our website, your website. I'm sure we can advertise it there as well. And just, I'm giving you at the bottom here of the screen. Hold a moment, I just want to bring that up quickly before we all log off. There it comes up. So you'll see that there is a email, rentals2@platinum@harcourts.co.za. That is Donita's email. So if everybody would like to send their questions to Donita, then hopefully we can set something up. Is Monday a good time for you guys? Is Monday a good day, bad day? Just have a quick look at the diaries there. And while they're looking at that, ladies and gents, it's not every day that you get a free 50-minute consultation with 3 different attorneys at absolutely no charge. So we just want to say to all the STBB staff and attorneys, thank you very much for participating today and just giving us all that updates. And you only have to wait the weekend to have all those questions answered that you posted today. Is that good for everyone? What does your program look like?
Yeah, I'm fine.
Are you good in the afternoon, rather?
Monday before 11 o'clock, Jan.
Before 11. Okay, yeah, that could happen. Absolutely. So let's just tie a time down right now. If we say, for instance, at 10, will that suit everybody? Is that prime time in the day?
Perfect.
Yeah, I think that's fine from my side.
Okay, beautiful. So we'll make a new link available, and then if everybody can just diarize 10 o'clock, and we'll correlate all the questions that we're going to ask you. So let's leave it at that for the time being, ladies and gents. Thank you so much for participating, guys. We really appreciate your time and your effort and your commitment to helping the industry and the public along. Thank you very, very very much. Okay.
Pleasure,
Thank
anytime,
you,
guys.
Jan.
Cheers, guys. All the best.
All right.
Bye.
Bye-bye.
Thanks, Jan.
Bye. Bye.
All the best.